Hey, good evening, everyone. This is the Planning Board meeting of February 13th, 2024. First item on the agenda is to introduce the other Planning Board members. So to my left is Steve Webster, who is an alternate. Sitting next to Steve is Von Dugan. And then next is Roger Murray. We do have a couple people missing tonight, one because of COVID, and the other, I'm not sure why. And then to my right, Jane Nielsen, and Brad Harriman, and Julie Jacobs. Since we have room for all three alternates, if you're all willing to sit, that would be good.
Yes.
Okay?
Yeah.
Okay, all right, great. Okay, there are no public hearings tonight, so basically we've got some discussion items that we need to go through. The first one is the voluntary lot merger from Austin White, North Wakefield Road, 093-004 and 093-005. Is the applicant here? Okay, well, okay, do you want to, go ahead, Roger.
We can't take any action on this because the ownership, there's not one owner for both parcels. The ownership is different. And under the statute, it has to have the same owner. So we need, if these are going to be merged, we need the owners to address that. One parcel is owned by Austin White, and the other is owned by Austin White and Tracy White.
Okay, so anybody else have anything they wanted to say? Tavis, does he also do these on a Class 6 road that in order to build a new house, he'd have to go to the Board of Selectmen?
No, this is a Class 5 section of road.
Okay, why does the assessor's card say something?
I can't vouch for what the assessors put on the card.
Okay, all right. Okay, then I guess we'll have to table this until,
Till we get the signature from the spouse, yes.
Now, they're going to need a deed conveying one of the, or they're going to need to put the property in one ownership, which is going to take a deed.
Okay. He had made it sound as though they were both in the same deed. I understand the tax cards are different, but we will address that with the applicant and he can come back.
I mean, they're going to need a deed either from his wife, a quitclaim deed from the wife to him and put it in his ownership, or they're going to need a deed from him to he and his wife, presumably his joint tenants, in order to have it in one ownership.
okay, do I need a motion to table this?
So moved.
Okay, somebody want to second it?
Second?
All in favor of tabling this lot merger to a later date, say aye.
Aye.
Opposed? Okay, thank you. The next one is a discussion about impact fees, alternative payment. And we have a memo from the property owner. This is a property on Club Lane. Tavis, did you want to make some comments, or do we want to hear from the applicant?
Are you doing the
What?
impact fee? Well, the applicant's not here, so. This is a house, as I noted in the memo, it's been under construction for a couple of years. They're now looking to get a certificate of occupancy. Certificate of occupancy can't be granted until the impact fee is paid. Section 175-173.8D allows the planning board to establish an alternate mutually acceptable schedule for payment of the impact fees. And it does require the applicant to post surety in the form of cash bond, letter of credit, or performance bond to guarantee future payments. But obviously, as the applicant is not here, you really can't have a mutually acceptable arrangement established.
Okay, so that applicant is not here.
Correct, they're not here.
Do we have the amount of the impact fee that's due?
Yes, it's the standard fee. It's, I want to say $4,840, something in that neighborhood. I can tell you in just a second.
Are you checking on something?
Only if you want the specific impact fee.
Okay. Does anybody have any questions before? I think we probably should table this until the property owner is here.
It would be helpful to know the amount that we're talking about.
Okay, Tavis, we're kind of waiting for you.
I understand. I can only go as fast as the internet allows me.
Oh, okay, all right. I'm not sure what
Some
you...
days it's not very fast.
What's that?
Some days it's not very fast.
So other than the fee, the house is,
Vaughn, can you speak into your mic? I can't hear you.
other than the impact fee, everything is ready for a CO?
That's my understanding, yes.
Okay, well, folks, you want to...
$4,184.
Okay, would the planning board members like to hear from the property owner, or how would you like to proceed?
So they did propose in the second memo that you have from them, or second letter from them, payment of up to $1,000, equal monthly payments with a maximum annual amount of $1,000 until it's paid. So if the board agrees with that, I think that's the only offer they have on the table. If the board is amenable to that, you can probably authorize it.
And does that become a lien on the property?
Well, the downside of the proposal they have is it doesn't, as I pointed out in the memo, does not address a cash bond, letter of credit, or performance bond. So equal payments
Right,
of...
so we would not be in accordance with the ordinance if we granted this, right? I mean, I don't believe that we've done this before, except Terry seemed to remember back quite a while ago, somebody paying, but I'm not sure what the whole details were.
Yes, when I first started here, there was somebody that was paying a nominal amount monthly. I don't know that this board actually went through this process under 173.8D to do it.
Right.
It's also curiously a little odd. It doesn't say the amount of the cash bond or letter of credit. I don't know if that's supposed to be for the full amount. It just says cash bond, letter of credit, or performance bond. It doesn't say in the amount of the total.
Well, it does say to guarantee further future payments of the assessed fees, so it would presumably, if they, whatever their down payment was, would be deducted, but This does not seem to give the planning board any right not to have security posted.
Correct.
So probably the easiest thing to do is to have them post a payment bond based on the amount due with some sort of plan. So if they put $1,000 down, then give us a payment bond for another $1,000 over the next 3 quarters or something like that, that's something that they could look into with their insurance agent.
Okay, could you mention that to them?
Payment bond.
Yep, I can do that. And ask them to be at the next meeting?
Yes, yeah.
Okay.
So Tavis, did you say at one point someone else was in the same position and they just worked through your office?
I don't know how it was arranged.
Yeah, we
It was,
don't really know the details.
It's kind of a
okay.
slippery slope.
But the ordinance is pretty clear as to
yeah,
what
okay.
can be done and what can't be done. Okay, so Roger, you want to make another motion to table this item?
I'll make a motion to table the,
Okay, and I'll second it. All in favor, please say aye.
Aye.
Opposed? Okay, very good. Okay, moving on to 19 Fawn Haven. Are you the owners? Okay. No.
hit the power switch.
if you need to be close, I would raise it and
You need to turn it on, too. Little slider button.
Here you go.
How's this? Better?
That's great.
Okay, great. Well, good evening. Thank you for your time this evening. I believe you've got a plan that was provided to you of a proposed addition. Why are we doing this? If I may, just a little history. My wife and I purchased the home back in fall of 2019. At the time, we recognized that it was, the lot was predominantly wetlands, but I can honestly say that at the time, we neither had the desire nor the intent to do any kind of tent to the home, modification, additions, et cetera. But since then, we have a family need. My wife's mother is in her early 80s, and a couple of years ago, she was diagnosed with Parkinson's disease. And with the progression, the family's decided that right now she currently resides in Connecticut. She's a New Hampshire native. And her desire is to, as care and progression, things of that nature, is to be close to her daughter as the primary caregiver when that time arises. But right now, it's pretty clear that she's getting close to the point where she shouldn't be on her own. She lives by herself in a house down in Connecticut. So her desire is to head in this direction. So that's sort of the background and the purpose of this addition. So our purpose this evening is just to try to feel out the board here before we get too far down the road and incur cost. And we recognize we have to get state permits and a full special use permit process here. But before we start, we just want to get a sense of the likelihood that we don't have any major obstacles that we have to hurdle to be that as long as we do everything according to the permit process, that this board doesn't have any big concerns that would prevent us from being able to do this. And as well as, and if so, then obviously the family would need to head down a different direction. So,
raise the microphone a little bit.
sure. How's that better?
Yep,
Thanks.
that's good. Okay, this was pretty controversial when it came to the planning board in 2018. And basically, what we ended up saying was that there really wasn't any more room for any development. So could you speak to that issue?
We purchased the home. I'm not familiar with any dialogue or any challenges back then.
But you must have had the plan, right, with the deck?
Yes.
Yeah, okay.
Yeah. And like I said, I mean, we like the home just as is. So this is If there were, I can't really speak to what all occurred back then.
Yeah, no, that's
Yeah.
okay. I just wanted you to know that
Yep.
really, we figured that there was no more room on the lot for anything. And so, and now you're taking the deck and switching it from one side of the house to the other, right?
I'm sorry, I didn't catch the first part of that. We're proposing,
Well, there is an approved deck on the plan.
yes,
Yeah, right.
that there is an existing deck, and,
Oh, that's an existing deck.
yeah, there is an existing deck on the top part. So what we would be doing is, where the existing deck is, that would become part of the addition, and then we would replace the deck on the other side, kind of like shifting it down to the left side of the back side of the house.
Okay, all right, so that is more impact on this lot.
And we are planning to, we assume that this would all, the deck is currently on sonopiers, and our intent would be to put this addition on piers as well,
Okay.
to minimize impact.
Okay, and you know that you'd have to start out by going to the state.
Correct.
Right,
You're-
okay. Anybody have any questions or comments?
I do. This wetland delineation was done in 2017. Has this been updated yet?
We had, Peter Kupadoc, we had him, since he did the one back then, he came back out and he prepared this.
Okay.
It's a preliminary. He's showing, he took measurements and kind of make sure that exactly where the house, as is right now, so he brought it up to date.
I'm just seeing 2017. I'm wondering if it's an old plan. But he's looked at it and it's more or
Yes,
less.
he actually prepared this.
Good, okay.
So,
There's a date of January 18, 2024 in the,
yes. Yeah. Yeah, yep. Yeah, he came out just before we had some significant snowfall, so, so basically just validate or confirm, because he hadn't been out post-construction, so we invited him out. He updated the one side, their existing conditions, and then showing where the proposed addition on the back there.
Anyone else?
Well, so usually when we are concerned about wetlands, and it's usually setbacks to wetlands, and in this case, there aren't any because we're already in the wetlands with the house and the deck, we look for whether or not there are any areas of less impact that you could put an additional volume in. And I see to the, let's see, that's north. It looks like there is some area within the 20-foot setback line before the retaining wall that is not a wetland. So that potentially would be an improvement in terms of wetland encroachment.
Yeah, I think we considered that in terms of our preference would be what we're proposing here. It's just what you may not see here is on the original structure, where the driveway is, so 25% roughly of our first floor plan is garage. So trying to work in, and we have septic as well as water lines going out, kind of just close to that area. We're trying to, if that is an avenue that we'd have to go, we'd have to kind of go back and reconsider what would flow and work best aesthetically as well as functionally for the home. So this is what we have an existing back door, so that back door would go right into the addition. So,
Another possibility is to convert the garage area into a living area, so that you don't get more into the wetlands.
yep.
One comment I have is in the south end of the lot, the red crosshatch is identified as upland, but then as you move toward the middle of the lot, the red crosshatch is referred to as buffer zone. So I don't know if the red crosshatch through and around the existing house is upland or buffer zone, or buffer/setback.
And it actually has both words in it.
Correct.
But since we're not talking about that area, doesn't
Well,
really.
I would suggest the board is, because the board's authority only goes up and through the buffer. It doesn't go into the wetland. So there is an area, arguably, between the rear of the existing home and the retaining wall that is apparently in crosshatch. So that's the only part the planning board would be looking at. But I think the state permit would need to be in hand before requesting to fill that gap with the planning board.
What about mitigation?
I don't know that we've ever done that before. You mean some exchange of
Yes.
creating some new wetlands or
Yes,
something?
so maybe taking some of the, improving the wetlands and mitigating, it's hard to explain, move it around, if you will, to create what you need near the house.
So this what?
Okay, anyone else?
Yeah, I have a couple of, is this on town water and town sewer?
It is.
That's good.
What is the size of the proposed addition?
20 by 30.
20 by 30?
Yeah.
Okay.
This is going to be year-round living space?
Yes, it'll be I don't want to call it an apartment because it's not going to be a kitchen or anything. It's really just when you exit our house, you go into a common area where it's large enough where she could do perhaps some potential physical therapy as well as entertain. It's really, we're trying to, in talking with the mother, she doesn't want to be on top of us. She wants to maintain some independent as well as if possible, for us to do it as well. So it's really a space that would give her her own little area where she has some family member in the area, other family members would be coming to visit her. And so having her own separate space would be able to give her the independence, privacy to do those types of things. So that's why we're envisioning it this way.
Are you going to be able to insulate that underneath, or is that going to be a problem?
Say that again.
Are you going to be able to insulate that sufficiently?
I've been told, we have not engaged a builder or talked specifically about construction, but I've just friends and family members that know a lot more than I do. They say that yes, it is possible to put enough insulation under there and all that and I've seen houses around that are up on piers.
That's true.
Yeah,
What's going to happen to the retaining wall?
it's going to stay there. I mean, where the if you look at where it extends beyond the side of the house, we're going to have an entryway there, and you can see that the deck right now is a step down out of the house. We're going to be raising it, so I don't envision. Again, the intent would not be to disturb the existing retaining wall. We're going to be on top of it. So,
And the addition would be on top of it as well?
yes, it'll be above it. Yep.
Anyone
Yeah,
else?
the retaining wall, elevation-wise, is probably at least a couple of feet, 2 to 3 feet below our first floor of our house, so.
There don't seem to be many contours on this. Do you have any idea which way this drains? Does it drain back onto the property? Does it drain toward the neighbor?
when you say drain, in terms of like roof runoff or just?
Yeah, well, in particular roof runoff.
Yeah, we really don't. I mean, I haven't noticed any kind of like active water moving. It's just when we get a lot of precipitation, we see puddles develop, really. But I haven't seen any kind of stream or like a flow of water, perhaps, anywhere in the property. Yeah.
It's relatively flat. Yeah, it's flat.
Yeah.
What?
Okay, yeah, you need to come up and speak if you're going to.
Yeah, she was saying that the only time we see really puddles and things developing is in the springtime, obviously, with thaw. But during the summer, it can be fairly dry, unless we get, 2 or 3 inches of water, and then those puddles, little by little, you can start to see them. But there's not, I wouldn't say there, to answer your question, it's a relatively flat contour. There's no slopes and banks and all that, so. I think when they built the house, they probably had to bring in a lot of fill, because we don't have a full basement, we just have a 4-foot crawl space. So the house, that's how it was built. And we assume because of the wetland issue of the property.
Is the area of the proposed addition, what is that now?
Just, where that resides, I can honestly say that it's not puddled. There's some stumps, there's just woods, leaves, We have no backyard.
It's not a lawn or landscaped or?
Nope, we've done nothing to the back of the property. When we're out there, we're on the deck, and that's about all. It's just wooded, it's woods.
Where is the garage located?
If you're looking at the proposed section here, this is Fawn Haven Drive, this is our driveway, so the garage is right here, this side. 2-car garage, 2 doors.
Well, the first step you would have to go through is New Hampshire DES, and then they would take the application and refer it back to the Conservation Commission.
Right.
And then eventually it would come to us. I still feel that it's it's a hard lot to develop, and I'm not sure that I would want to see any further development. So, but it's just me.
You're saying you don't see further development possible? Is that what you're saying?
Yeah.
And that's what we're trying to assess, is before we get
Well,
too far
it's-
out over our skis and go through the formal permitting process, if there's I don't say opposition, but just a big lift to be able to get the permit.
Yeah,
That's what we're trying to
right.
assess.
I know, that's why I was,
Okay.
yeah, I mean, there were neighbors that were concerned, and it was, it was a difficult one for us to approve with the plans that we had. So, but, I mean, I'm not sure exactly what the plans are going to entail, how much intrusion there'll be into the buffer or wetlands, and so, until I see more complete plans. Any other?
Could you just point out one more time which small bits are actually wetland that you're trying to build over? Because you've got the existing house that looks like it's completely in the wetlands from the way that Peter's drawn this.
Yeah, I think the whole area there is wetlands.
Everything beyond the retaining wall.
Correct. And
So technically,
probably,
it's
my guess is prior to the construction, even where the house is, was considered wetlands.
It
And
was,
that,
yeah.
and they brought in all the fill and everything, and that's how they built it. So,
So then technically, everything that's been built is not wetlands anymore, correct? And it's just that little bit of the deck, the new portion of the deck that would be extending into the wetlands? Is that the way I'm seeing the crosshatching?
Yes, there's a little bit of the deck right now that goes beyond the retaining wall that's over wetlands, according to this map.
And that's the only bits that are causing the huge problem that is going to cause it to go to DES? Yes?
Well, the 20 by 30 is pretty much completely beyond the wall, which is over wetlands.
I thought the wetlands was just the crosshatched piece.
No.
That's my
No,
question.
the opposite. The little thing that looks like a porcupine.
So all the white with all the little
Yeah.
bits
Yeah, that's the
is also
wetlands.
wetlands?
Yeah,
So what's the crosshatching then?
That's upland.
that's upland. That's
Or,
dry.
or buffer.
That's not wetland.
So that's not wetlands. That makes a difference.
That's the 30-foot wetland
Just make
setback.
note, there's no key on
The
this map.
setbacks aren't even on here. There is
You know
no.
what, I was looking at it
Isn't
that way
that
too. I was like,
Yeah, I mean, but
and now yeah.
Okay, Tavis, did you want to add anything?
No, I think the applicant kind of heard from the board, which is what they were looking for.
Okay,
I guess I would share Kathy's concerns, and I think, if you're looking for, one of the things to consider is whether there's any other spot on the property this could be done. And the fact that you have a two-car garage, I think, is a place it could go.
okay.
okay, anyone else want to make any comments?
I mean, I think if you want to get a perspective on this, you could look at the old planning board minutes. We fought hard not to allow this whole lot to be developed.
Okay.
So,
Right.
and the neighbors did too. So it's an issue to add on to something that, was hard fought in the beginning.
Okay. That's good to know the history, so, thank you.
Lift.
Okay,
Okay, well, thank you for your time.
yeah,
We do
okay.
appreciate
Appreciate
you
it.
coming in
Yeah,
and
yeah.
discussing it with us, so that
Right.
at least you can get some indication before, you spent time and energy.
Right, that's why we're here. Right,
Okay,
go ahead, you want to ask a question?
I just
She's got it.
the apartment in the garage, would still let us two-car garage to the right, or would we have garage?
No, my wife was asking that hypothetically, if we redesign and did something off to in the upland area, which would be less of an impact. Obviously, if we turned our existing garage into living space for her, then we would be without a garage. So if we added a garage off to the side, catty-cornered it or something to try to minimize impact, whether would be more palatable.
Again, I think the missing detail is whether the crosshatch is buffer or upland.
Okay.
right.
And what Vernstone can definitely determine whether it's buffer or setback, but I think you're going to be in setback anyway, which would require
Yes,
coming back
yeah,
here.
it looks that way.
Okay. All right, thank you.
Okay, all right, well, thank you very much for coming in. Okay. Lakes Region Planning Commission.
Yeah, so the brief background on this is that Amy Muccio and I received some emails from Lakes Region Planning Commission, originally looking at both Roger's and my appointment dates. And after suggesting to Roger that was going to be discussed following the deliberative session, we weaned it down. Roger's appointment is good through 2026. My appointment to Lakes Region Planning Commission is still in good standing, but as of July, apparently, my appointment to the Transportation Advisory Committee has run out. So what I put in the packet for you was a draft memo for Kathy's signature, simply looking for a 2-year term. Ultimately, then, this would turn into a memo going to the Board of Selectmen for a 2-year term that would end 2 days, or 2 years from the date they actually make that motion. So that's all this is requesting. And if the board would like another member to be the TAC representative, I will not be offended.
No, do you want to do it?
Happy to.
Okay. All right, well, I'll make a motion to pass on to the Board of Selectmen that we feel that Tavis would be a good choice for this, for the TAC meeting.
Seconded,
Second.
thirded.
Fourth.
All in favor, please say aye.
Aye.
All right. All opposed? Okay, you're all set. Let's see. Okay, you want to update us on legal issues?
Yes, so as the board probably recalls, you recently approved a conditional use permit for an accessory dwelling unit at 16 Libby Street. Within 30 days of that decision, 2 appeals were filed. One was filed by Mr. Hart, which was made to the Housing Appeals Board. And the second is an appeal by Audrey Klein representing Roger Kent, who is appealing the planning board decision. So in preparation for the ZBA meeting, which occurred on February 5th, Kathy and Doug asked that I reach out to planning board counsel to see who, if anyone, should attend, what, if anything, should be said. And the outcome of that was the letter that you have in front of you this evening, which was presented to the zoning board on the 5th, was presented as public comment to them. Zoning board continued their hearing until February 22nd. And I do not yet have a date from your attorney or from the Housing Appeals Board as to when that hearing will be held. All are open to the public. You can either go in person, or I can share the WebEx link for all of you who are interested in going or watching anyway, just to see how the Housing Appeals Board works. But that is solely being handled by Planning Board counsel,
By,
your Planning Board attorney.
okay. Okay, well, I mean, basically, this letter that she submitted said that they really don't have jurisdiction to hear this because it's an innovative land use application, so, I mean.
Kathy, this is just a copy of the letter. This is a zoning board letter.
What?
This is to the zoning board. This isn't to us.
Yes, right.
So not telling us that we don't have jurisdiction.
No.
Oh, that's
This
what it
is-
just sounded like
This
what you said.
letter was done to give to the zoning board at their hearing. And so,
Did the ZBA have a letter from their attorney saying they did have jurisdiction?
I am not aware of such a communication.
I mean, they proceeded with the hearing.
They did.
Yeah.
The first words on the case were, I make a motion that we have jurisdiction, and it was seconded, and off they went.
Okay.
But once they opened the hearing, they received copies of this letter along with a motion to dismiss from Mr. Beckwith's attorney.
Was the recommendation that someone speak on behalf of the planning board, or that this was sufficient?
That might be a question for a non-public.
Okay,
Thanks for bringing the letter so we could read it too.
Yeah, there was a question asked, a response given, and then a subsequent request for a letter to be generated, which is what you have in front of you.
okay, so we have the letter that Laura sent to the ZBA on our behalf. And at the ZBA meeting, they said that they would decide the jurisdiction issue first and then go on to the rest of it, is what I remember. And so that's the ZBA case, right? Okay, Roger, did you have some thoughts about the other case?
Yeah, I'd be interested to hear what our attorney said about the ZBA case. But yeah, we filed an answer in the Housing Appeals.
Yes, correct.
Can we get, I tried to go out and find something there and with the Housing Appeals Board, and well, I found the name of the case and a lot of TBDs. But I'd be interested in seeing what we filed for an answer, and it would be interesting if we could at least see something that kept pace with what's been filed. So if anybody asks us, we can offer at least an explanation on the status. Is there anticipation that someone from the planning board will be speaking at the hearing? I haven't looked at the regulations governing the Housing Appeals Board, the administrative rules. But is it an evidentiary hearing? Is it just done with attorneys, basically, or?
Are you talking about speaking at the Housing Appeals
Yeah.
Court? Yeah. Okay, well, I mean, I think Laura has all the information.
She has all the information the way it was laid out to
And she
me
would
is.
make that decision, I think.
What's that?
I would think that she would make that decision if she wants somebody from the planning board.
Correct. That's how I understand it, yes.
Yeah, I would assume the same thing. I'm just curious.
I can share everything with board members on what's gone to the Housing Appeals Board, if that's what the board wants. I'm not trying to keep things from you.
Okay,
What's the current status of the, the application
For which?
for the ADU?
The ADU building permit can be issued, if that's the opinion of the planning board attorney. Certificate of occupancy can be granted, but each of them should have a disclaimer on the bottom saying subject to appeal. So basically, the applicant for the ADU is on hold until the two cases resolve.
But you could do a CO. They could use the structure with notice that it's under appeal.
I suppose you could. I don't know if I personally would rent a space to someone saying, you're good for a month or maybe 2 weeks, or maybe forever.
okay, anything else?
Has Mr. Brown done anything?
Mr. Brem has not reached out about next steps for the project that the board discussed.
Okay, can we go on to the next item? I had sent all of you a memo on pending items that the planning board has discussed. We're working on the conservation subdivision, and That will come to the planning board in March of next month. The road discussion, I think we're going to have a discussion about that at the next meeting, is that right, Tavis? And then set the public hearing for the road construction.
We can do that, sir.
Okay. And the solar ordinance, we're waiting for a final review or comments from the Energy Committee. So that will probably be coming along, but I bet not probably until later in the summer. So I then went down a list of things that we have talked about, and I think we need your input here in order to decide how we're going to move ahead. Short-term rentals, there's been a lot of discussion about that. We got to do something. Multifamily housing, the petition warrant article, we didn't find very clear. But, you know, obviously there's thoughts out there about the multifamily housing, so it seems like we should have some sort of a meeting that would focus on that issue. The water sewer issue, we're still waiting for the Board of Selectmen, and so we're waiting. Okay.
We are too.
Okay. The manufactured housing, when we looked at this ordinance, when Jody Hutch came forward, we said it really needed some work. So that's another item. And then the impact fee, the consultants that came to see us last year said this really needs to be reviewed. So we've got the ordinance, and it's just the way of proceeding that we can move ahead and decide on impact fees and review it, see if it's still needed and doable.
Wasn't there some issue on impact fees with the school district?
With the what?
The school district,
There was a question on how they were using it and, you know, what the money was coming from and a demonstration of what it was being used for.
Right, okay.
I don't know
And
if we ever got the answer to that.
Well, we did. Ultimately, it's not really a school problem so much as when the town was taking the some of the impact fees up. It was outside their budget year, so the money was always going into unanticipated revenue. So it became harder to track that way. So we fixed the problem on our end, so now the checks are going at the appropriate time. So that's going to, you know, now when it comes in, it gets earmarked as Wolfeboro impact fee and then is used in accordance.
And does that reduce our tax rate, the school portion of?
Yes.
Yeah.
That's what it was designed to do, is to reduce
Right.
the school
I just
portion
wanted
of
to
the
make
tax.
sure that it was clear that that's what was happening.
Correct.
okay, anyway, it seems we need to work on that. The other issue is the natural resources chapter of the master plan. There is a consultant. We met with the Conservation Commission. They wanted to see an update of it, and so that's going on now, and I'm not sure if that's going to be done this year or next year. Tavis, what do you think, next year?
Well, currently the contractor's working on updating all of the maps for the natural resources section.
Yeah,
So there's not money allocated in the '24 proposed budget for redoing the chapter. But that doesn't mean it can't be done with staff and board members.
right, okay. So anyway, that's an issue that needs to be dealt with. And then my favorite issue, should we consider again eliminating the C2 district? Could we try that again?
Well,
Next year, not this year.
The C2 district is functionally gone. There are just pages that refer to it still in the ordinance.
So it's housekeeping.
There is currently no
right.
property zone C2, but we have C2 in the land use regulations.
Is it on the map?
It's on the last map that was created, but it was an error when it showed up on the map.
I see.
I mean, I think a lot of these are rehashes of all of the zoning items.
Well, there are things that we need to deal with.
No, can I finish?
Yep,
Yeah.
sorry.
That were to do with all of the, 1 through 12 or 1 through 10 that just got blanket denied by the voters, after some pressure. Maybe we should talk about all of those. There's definitely a merit for each of these items of those, and either change them a little or explain them more clearly, because that was the chief complaint, and bring them back up. They shouldn't just die because of a mass, voting bloc that wanted to reject everything.
Right, not only that, all those went to hearing too, and they all kind of got through the hearing process without too much trouble. So
We
they're
have
like
to maybe
three-quarters done.
rephrase. But all of these issues, almost, were part of that.
Well, in looking at short-term rentals, I did put together a memo and a draft licensing protocol and sent it to the town manager, which I haven't reconnected with him on. But I'll have an opportunity on Thursday to meet with him, and I'll see if that can move forward. Many communities seem to be having better luck going through a licensing mechanism than a zoning change. And that's something that doesn't have to wait for town meeting. That's something the selectmen can have a public hearing on and just move forward. So I guess we can wait for the water and sewer report while they wait for our data on input on short-term rentals.
I think another approach too could be to, Vaughn's right, would, have basically all 10 of those items from last year. Instead of trying to do all of them at once, what do we, if we handpicked and maybe did a third or half of them at a time, concentrate on those to get the wording right and get it, publicized, get it out in the public so that everybody understands it, and approach it that way so that we're not putting so much out in front of the people each time. Might
Right.
have a better approach and better results.
Okay, well, the multifamily housing has come up several times, so it probably would be good to consider that.
Well, and the whole concept of what is a manufactured house. I mean, all sorts of parts of houses are manufactured. Sometimes the whole thing is brought in. I mean, it's a term that is very gray in this day and age, and maybe we should have it go away and figure out what we're trying to regulate.
It's pretty dated at this point, right, that one?
Yes,
So-
yes, it is.
Terms change, they go away, industries change, so it's probably not even a valid term at this rate.
Okay, so what about the accessory dwelling? You want to do a couple this next year, or how do you feel about that?
Well, I think we should bring them all up and then give them a list of priority, all of the items that were on that list, and then
Okay.
prioritize and discuss the ones that are our top priority.
Maybe,
Okay.
maybe
And
for,
the easiest ones.
I mean, there's plenty of room on your next agenda for the 20th. If you want to come back with a priority list, you can compare notes with one another, and that's what we'll come back with.
Yeah, that would be great. Okay, so people, you want to do that? Okay, all right. Yeah, because I don't think we have any applications, so.
I'd like to ask that we move the discussion of the conservation subdivision to our work session meeting, just because I'm going to miss the
Yeah,
first one. I'd like to be here.
Yeah, I think we agreed we wanted to do that after the town meeting, so there was not confusion about what was being proposed this year and what was in the future.
Okay,
So
all right, so people are going to put some thought into this, and,
Well, if conservation subdivision isn't going to come next week, and it wants to go to the work session in March, that'll be the 19th.
yeah, right.
No, that's fine. So then the question is, do you want to meet next Tuesday just to go over your priorities?
Yeah, I think we should, so that we can get moving on these things.
Okay.
Didn't we continue lifetimes to March 19th,
Yes.
which could fill up?
I will reach out to Mr. Brem and see if he is still planning on holding that date or not.
Okay. Public comments. Anyone want to make public comments? All right.
Ann Blodgett. So the agenda item with the wetlands conceptual, about 10 people said to me, "What is that?" The agenda was so unspecific. It said nothing. So people watching on TV and people who might have come to the meeting are like, I don't know what it is. So can the agendas be more transparent, please, or specific?
Sure.
Because I'm sitting here, you guys are talking about a piece of property. I have no idea what you're talking about.
Okay.
Is that a fair request?
Yep, yep.
Okay. Thank you. And then,
I mean, functionally speaking, all I could really put on the agenda was the address.
well, you didn't.
No, but I mean, that would be the only other level of detail that could,
That's fine, because I could look it up and at least know what you're talking about. I feel like I came and listened to a conversation about no idea. And people at home, even worse. And I think a lot of people, as evidenced at the deliberative session, want to be engaged. So can you help with that? And then secondly, short-term rentals, I don't want to beat a dead horse, but they're still screwing up the real estate market, first-time home buyers. They're still screwing up the long-term rental market, because short-term rentals that can't rent short-term are renting seasonal. So it's driving a lot of real estate into a weird direction. And, the first-time home buyers are still getting turned away, and then we're going to get, we're still getting developers coming in to tear things down and turn them into Airbnbs. So I think it's really a pressing issue. And, it's using up housing. It's the same, it's the same stuff. And that's beating the dead horse. But if you guys made that a priority, warrant articles 2 through 10 last year, I think many people would agree that it wasn't that they were confused, they didn't like them. So, but I think you heard in this room that short-term rentals really came to the top. So, thank you.
Okay, thank you. Okay, minutes from January 16th, 2024. Peter Goodwin got in touch with me and wants to make a correction on page 4. It's almost at the bottom of the page, where Peter Goodwin stated he agrees with John Thurston. And he added at the end of that paragraph, however, the board is following the regulations, so it is technically correct. And anybody else have anything they?
Yeah, I'm going to have to fill in, I guess, for Doug, since he's not here. On page 6, midway down the bold line, I think at the top of the page, it was a special use permit that was continued, and then in the middle of the page, it was the site plan application, which was denied without prejudice, I believe. Not the special use permit, which appears twice.
Correct.
And then on page 7, the middle of the page, I'd like to rewrite part of that. Beginning with, it says Roger Murray stated he spoke with Tavis Austin, then it states he stated, and I believe that was me stating, not Tavis. And then in the next line down, should read, Roger stated he believes the intent of the petition to be to create uniformity in the permitted uses, and then I would change it to read, and multifamily ordinance. Because that was where you've multifamily listed in some districts and not others, but when you looked at the multifamily ordinance, it basically allowed multifamily in all the commercial districts, and I think more of the residential districts. And then in the third line, interpretation could be to no longer allow multifamily dwellings in certain residential districts, and then I would end that paragraph after clarified. And then the very last line on that page, I believe it should be Roger Murray stated zoning warrant articles are not discussed. And that's what I have.
Oh, okay, how do you want that? It should be planning board petitions, shouldn't it?
No, it's zoning warrant articles, not
Yeah,
whether they're petitioned or not, they're not discussed.
yeah, okay. Okay. I'll make a motion to accept the corrected minutes of January 16th, 2024. Somebody want to second it?
Second?
Motion has been made and seconded.
Seconded.
All in favor, please say aye.
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 Okay, all right. Anything else, Tavis? Tavis and I are doing our little TV thing on Thursday on the warrant article.
Are you going to discuss the petition warrant article?
Yes, we are, yeah.
Does anybody want to hear what our attorney had to say about either of the appeals in a non-public session?
I have a question before you start that, Roger. Can you discuss that, or are you just going to read it? The warrant article, petition warrant article. Kathy just said you're going to discuss it.
Yeah, no, we're just gonna,
You're just going to read it.
yeah, and just.
Read it and explain it.
Explain it,
Right.
right.
Okay.
Okay.
I didn't put the petition in the PowerPoint, so if you want something added, we should discuss that.
Okay, well, I think something probably should be in, so people,
If nothing other than why we didn't recommend it.
what was that?
Maybe state why we didn't recommend it.
Well, why I'm asking is because it bothered me that we couldn't say anything about it last time, so I actually called Randy Walker. Actually, I called Pat first and asked her, and she said, call Randy. So I called Randy before the deliberative session, and I said, since we couldn't discuss the petition warrant article at the open meeting we had, can it be read before the deliberative session so that everyone understands that there is a petition warrant article in the beginning instead of at the very end at midnight, like you normally wait for them? And his long answer after 10 minutes of us discussing it was, no, cannot. He did say that, number one is, people, voting on people. Number two is the one that we have. And number three is petition warrant article, and then immediately jumped right ahead to the rest of the stuff because he's not allowed to say anything. So my question is, do you really want to discuss it or just read it? I didn't watch the ones that you guys did for the rest of the ones. Did you, at the end, when the petition warrant articles came in, did you just read them? Or did you not read them at all?
We read them.
Yeah,
You just read them?
right,
So it should probably keep suit.
yeah, that's.
Because then if you discuss them, then you're
Yeah,
opening
no,
up a big
no, we're
can of
not going to
worms.
discuss it, we're just going to read what's going to be on the ballot and say why the planning board did not approve it.
Well, then that's discussing it.
No, that's reading, because you're going to have, that's part of the article, because it says on the bottom, recommended or not recommended. And
Right.
we read that on all of our warrant
Yeah,
articles.
right, and
So that's part of it.
Yeah. Okay, anything
Because
else?
you can't say much.
What?
It's like if you say too much, you're going to get in trouble,
Yeah, no, I agree. Okay. All right, anything else? Anybody?
Anybody want to hear from our attorney?
About what?
The two appeals? Tavis seemed to suggest there was something that was not contained in the letter.
No, just the history of how the letter became a thing. I mean, the board doesn't have to have a non-public if you, all of you are privy to it.
You're going to fix it so that we can see the answer and,
Well, I'm not going to fix it, I'm just going to share what I've received
okay, yeah, that sounds good.
on the Housing Appeals Board, yes.
Yeah.
Okay. Motion to adjourn,
So moved.
Seconded.
all in favor? Aye.
Aye.
Opposed? Okay, all right, thank you, folks.